Welcome to U.S. Immigration Enforcement, Making Sense of Immigration in 2025. I'm Samantha Seves, and I am one of the membership committee chairs of the BHBA's Barrister section. I am delighted to introduce our speaker today, Nancy Canter. Nancy is an accomplished litigator with deep expertise in federal immigration law. As a senior litigation counsel at the U.S. Department of Justice, she advised senior leadership at the Department of Justice, the Department of Homeland Security, the State Department, and Department of Health and Human Services on complex immigration policy and regulatory matters. She has led litigation strategies in high-profile cases nationwide, including challenges to immigration regulations and constitutional claims, and has argued numerous appeals before the federal circuit courts. With this extensive background, Ms. Canter brings unique insight into the intersection of immigration, administrative law, and constitutional issues. Now, let's get started.
Thank you so much. I'm so excited to be here. Obviously, as we just talked about, I spent 15 years with the government as an immigration attorney. The bulk of that time was with the Department of Justice, Office of Immigration Litigation, but I also spent 2 years with USCIS, kind of sandwiched in between those 15 years with the Department of Justice. During my practice with the government, I did a very large volume of cases in the courts of appeals, handling primarily petitions for review, but also did class actions regarding unaccompanied minors and visa delay processing and APA challenges. Work closely with agency counsel to develop new policies, to kind of inform how the government approached immigration policies and changes in administration. And obviously immigration has been a very hot topic for so many years, and I think never more so than now. I frequently, almost daily, get questions from friends, colleagues, my family members on what's going on with the news. Why is this happening? I don't understand. We could spend probably a whole week discussing immigration issues and not even scratch the surface of what's happening in the news today. I think the goal of this session today is to give you all some context as to why we are kind of facing the issues that we are facing today, a high level overview of immigration law, what policies and practices have led us to the situation we find ourselves in today. And the goal is for you all to be able to better identify kind of the issues your clients or family members may be facing, but also to provide some insight and issue spotting and abilities to understand why we are where we are today. I think one of the big issues that we hear most common with immigration is, why don't folks just come here legally? And as an immigrant myself, who my family immigrated to the United States in the 1980s and early 1990s, I know many that have benefited from legal immigration. I think what many folks don't understand today, individuals who aren't deeply entrenched in the immigration system, is just how increasingly difficult it has been to legally immigrate to the United States unless you have an immediate family member who is present in the United States. I want to start with kind of the key sources of immigration law. There's Title 8 of the U.S. Code. This is where the statutes governing immigration and nationality are found. There are also accompanying regulations which clarify and implement the statutes that are found in Title 8. Then there's also the federal criminal law, criminal code, which is Title 18 of the U.S. Code. Now, you all may hear the phrase crimmigration, and crimmigration is kind of a cute shortcut for the interplay between criminal law on the immigrant population and how criminal conduct can impact an individual's immigration status. Then, to further kind of heighten and complicate matters, there is state law. There are so many matters of state law that influence immigration status. For example, for children seeking derivative citizenship, you can get into very many questions about custodial parents, divorce, marriage. All of those issues are determined by state law, but how state law is written and interpreted, including state criminal laws, can really have a significant and profound impact on an individual's immigration status. And then finally, there's the impact of foreign laws. There are, of course, I think one of the big issues that have popped up recently are principles like refoulement, non-refoulement, which is the principle of international law that prohibits states from returning individuals to a country where they fear real risk of persecution. But just like state laws impact your federal immigration status, foreign laws and how foreign law treats divorces, marriage, custody can also have a significant impact on an individual's immigration status. So these are the primary sources of immigration law. Of course, there is also, court opinions and treatises, et cetera, secondary sources as well that impact immigration law. For a brief overview of the main agencies involved, I have here 4. It seems very clear-cut and simple, but I think one thing that we've seen in the last few months is that it's not that simple, and that the far reach, because immigration is a federal issue, it can very quickly implicate so many aspects of the federal system. The primary agencies, of course, the big one that everyone knows about is the Department of Homeland Security. Within the Department of Homeland Security, there are so many sub-agencies. There is ICE, and then within ICE, there are sub-agencies as well. There's CBP, there's USCIS. I like to think of DHS as a enforcement/benefits agency. They conduct removal border enforcement, but USCIS aspect of it does the benefits. They do the, LPR status, they do asylum, etc. The Department of Justice also has a big involvement and role in immigration. Within that, there are sub-agencies, the Executive Office of Immigration Review, which houses immigration judges and the Board of Immigration Appeals. There's the Civil Division, Office of Immigration Litigation, that handles the petitions for review, as well as cases that are filed in the federal district courts. There's also the U.S. Attorney's offices that handle a large number of immigration cases that are filed within their individual districts. And then there's the FBI. We regularly, part of the Department of Justice, coordinated with the FBI as part of investigations, but also because the FBI holds kind of, all of the background and biometrical information about individuals. And then there's also the Department of State. The Department of State largely gets involved with immigration for individuals who are abroad. So for individuals seeking to come to the United States from outside of the United States, they would deal with the Office of Consular Affairs. And refugees seeking to come to the United States work with the Bureau of Population, Refugees, and Migration. And then finally, there's the Department of Labor, which does all of the labor certifications, prevailing wage determinations, for determining, the number of foreign workers that can come to the United States that won't have an adverse impact on U.S. workers. Those are, I think, the most common federal agencies that are involved when you think about immigration. But because immigration is a federal matter, there's always the possibility that other agencies will be involved. And what we've seen a lot of historically in the past was involvement by HHS, Health and Human Services. They actually have custody and control over unaccompanied minors. So HHS and ICE and DHS work together when there are unaccompanied minors who come into the custody of the federal government. And then, of course, there's a lot of buzz, I think, recently about kind of the immigration concerns with tax records and Social Security records. So there's kind of no real limit to the number of federal agencies that can be involved. I would say that for most people, though, DHS, DOJ, State Department, and the Department of Labor would be the ones you come into contact with most likely. This slide kind of provides a quick overview of the 1996 Illegal Immigration Reform and Immigrant Responsibility Act. We refer to that as ARIRA or ARIRA, depending on how, I guess, the first time you heard the abbreviation. But this was the last real comprehensive immigration legislation that Congress passed. And that was quite a while ago, 1996. But ARIRA really fundamentally restructured U.S. immigration law to focus on stricter enforcement and harsher penalties for undocumented individuals. The law significantly expanded the grounds for deportation and limited the avenues for legal relief. Some of the things that the law did, I have a brief summary here on the slide, but it created reentry bars. So for instance, it created a 3-year bar to reentry or 10-year bar or even a permanent lifetime bar on reentry for individuals who accrue certain periods of unlawful physical presence. It also created expedited removal, which gives immigration officials the power to very quickly or summarily remove individuals before they have the opportunity to have a hearing before an immigration judge. It also expanded deportable offenses, made it possible to deport individuals who are here undocumented, but also lawful permanent residents for a significantly broader range of crimes, even for past minor offenses. It also expanded border enforcement by boosting funding for Border Patrol agents and technology. One thing that it did was limit judicial discretion. As kind of these enforcement mechanisms came into place, ARERA also put into place jurisdiction stripping provisions so that individuals could not seek review over certain determinations made by the agency in the federal courts. It also, and I think this one is particularly salient or something that we think about or hear about a lot now, is created the 287G initiative, where the federal government has kind of a so-called cooperation with state or local governments. And that has evolved over the years. But the point I think here is to show that, or to indicate that the last time Congress really did anything on immigration significant was 1996. There have been a number of attempts to pass immigration reform, none of which have been successful. Unfortunately, that means that our system hasn't really changed or advanced. I mean, for anyone who's been doing immigration for a long time, we can say that we have a number of ideas for what we could do or what we should do. But unfortunately, because Congress can't pass any laws, we are left to rely on one, executive action and kind of administrative policies, as well as the courts, right? So you have now the administration and the shifting administration, right? Depending on what side, what party is in power and what their politics and priorities are, as well as the court system to kind of shape immigration law. So critics of ARERA will say that the law led to a massive expansion of immigration detention system and a separation of families, where, you know, the intended effect of ARERA was really to kind of deter undocumented immigration. You know, depending on what studies you look at, it suggests that maybe what would have happened, or what really happened with ARERA, was that it incentivized people to stay because of the aforementioned reentry bars. If you are going to leave and come back, you may find yourself subject to a permanent reentry bar. So thinking about kind of our hot topics of immigration, it was really hard to choose and come up with 5, but if I had to, what the 5 that I kind of came up with was removals, being kind of what is happening with individuals who are here and unlawfully present in the United States, not only in immigration courts, but also kind of what we're seeing, the expedited removal process that's happening at the border, as well as the more concerning removals to third countries. We're also seeing a lot of buzz about visa cancellations, and with, you know, the State Department taking the position that a visa is a privilege, not a right, and that it can be canceled at any time. So we've seen visa cancellations en masse as to foreign students, the suggestion that there's going to be, you know, a significant impact or crackdown on employment visas, and then even more concerning, just a blanket review of all individuals here present in the United States on visas. There's also been a large impact of the refugee admissions. This doesn't, I think, get quite as much press as some of the other topics, but, you know, the U.S. refugee admissions program has been effectively shut down since the early part of this year. That's resulted in not only a number of individuals being left in limbo, individuals who have had their refugee applications processed and approved, but haven't yet traveled to the United States. But what's lost in that is the significant federal funding that went to refugee programs, refugee resettlement programs, and support programs within the United States. So that funding has been put in jeopardy. and has been suspended. And also the individuals who have recently resettled into the United States as refugees have lost that funding and support. There's also, go back. There's also asylum. Asylum is kind of a big topic. I think what people, many folks who aren't in the immigration space don't realize is that there are over 3 million pending asylum applications currently, and that number continues to grow. That backlog has grown significantly since COVID, and it continues to grow. The problem is that you have individuals who are kind of in a state of limbo. They can get, temporary work authorization, but individuals who, have been pending for, say, 4 or 5 years, who might have had a valid asylum claim many years ago, are now in a different political climate where they may be facing different risks because they haven't obtained that asylum status yet. And then finally, general immigration enforcement. That's kind of an amorphous category, but I think that kind of captures the sense that I get from most folks asking questions these days is, what is going on? The immigration enforcement that this administration has kind of made a priority seems to focus a lot more on expulsion versus just active deterrence of entry, but expulsion from within. And that has increased the number of enforcement actions taken across the country, impacting communities. I know here in LA, that's been a huge issue since, for a while, but it has been very alarming to see that continue and also grow throughout the country. So, kind of understand where we are. The US immigrant population is, generally speaking, all individuals not born in the United States. So I would include myself in that number because I was born abroad, naturalized. The total population of the United States is about 340 million people. The immigrant population, approximately 50 million individuals, not a certain number. That means that it's only 15% of the whole US population that is not native born citizens. So when I think about it, immigration is such a hot topic, but it's really only 15% of our total population. And then when you break it down even further, of that 15%, that's broken down to approximately 49% of the US immigrant population is naturalized, 24% hold lawful permanent resident status, 23% consists of unauthorized immigrants, and then 4% have long-term non-immigrant residents. So those are individuals here on long-term non-immigrant visa status. If you look at the pie chart, I think it's interesting to see. Again, this is only 15% of the US population that we're talking about. And one thing to note is that these percentages don't tend to shift significantly over decades because people move in and out of these status, right? So you may have unauthorized immigrants who move into lawful permanent resident status, lawful permanent resident status individuals moving into naturalized citizen status, and so on and so forth. So the actual percentages do not tend to shift significantly based on turnover and change in status. I think once we understand the population of individuals, the question that everyone has is, how do you become a lawful permanent resident or a long-term citizen or a long-term immigrant? Generally speaking, if you are outside of the United States and you want to come to the US, you need to seek a visa. There are 2 types of visas, non-immigrant and immigrant visas. A non-immigrant visa is intended for individuals who want to come on a temporary basis for a specific purpose. That can be anything from tourism, a few months, or even a few days or weeks, to business, temporary work, or study. So it could be, somebody who wants to come and visit a family member for a week, or somebody who wants to come and enter into a long course of study. If you are present in the United States on a non-immigrant visa, you are restricted to the activity or reason for which you are admitted. So if you are here on a student visa, you need to stay in that student visa status and continue to comply with the conditions on that status. There may be restrictions on your ability to work, and it becomes dicey, I think, for individuals who think that it's very easy to move from one status to another. I know one common question that I got from individuals who had au pairs was they would have au pairs, and their au pairs would want to stay. And obviously the au pairs were here on a very specific type of visa. And once their 2-year au pair agreement came to an end, it was often very difficult, if not impossible, to find another visa status for which they could stay in the United States. Then there is also immigrant visas for permanent residency. An immigrant visa is what it sounds like. The individual plans to come and live permanently in the United States, and the holders of the visa, once admitted, are lawful permanent residents or green card holders. This type of visa typically involves sponsorship by a relative or employer, although some individuals, a very small, increasingly small number, it feels like, may be able to petition for this on their own behalf. So again, this is a summary of different kinds of immigrant visas. The most common type is the family-sponsored visa. This is for individuals who are sponsored by family members who are already here in the United States. We'll talk more about this later, but the goal of the family-sponsored visa is, family reunification. There is also the employer-sponsored visa. This is where your job can sponsor you to come to the U.S. Many of these are non-immigrant visas, but there are also some options for conversion to permanent visas or permanent immigrant visas. Then there's the diversity visa lottery. The diversity visa is exactly what it sounds like. It is a lottery. There is a 0.2 chance of being selected, and it excludes the top origin countries for legal immigrants. So there is a very, very small number of successful diversity visa applicants. And then there are refugees, and there is a 0.1% chance of being selected as a refugee. I think that the U.S. immigration system kind of has its focus and goals, namely, family sponsored is to foster family reunification, employer sponsored, which is to kind of promote growth in the U.S. economy, and then diversity and refugee is to promote diversity and humanitarian aspects. So these are kind of the overarching goals, I think, of USCIS and the Department of State, who are the agencies who are responsible for kind of facilitating these visas. So this chart contains a breakdown of green card holders or individuals with lawful permanent resident status. And lawful permanent resident status is the status that you have before you can naturalize and become a US citizen. As the pie chart shows, 47% of LPRs or green card holders are those who come because of immediate relatives, and that is a spouse, a child, I can't remember off the top of my head, maybe a parent. And then there are non-immediate family sponsored, which is 17%. So that would be like your brother, your sister, the more attenuated your family relationship. There would be employment based, which is the same amount, 17%, and then a much, much smaller amount in terms of individuals who are admitted as refugees or asylees, and then diversity visas. So I think, this all sounds great, right? Like, that's great. These are laudable goals for the United States. We want to foster family reunification. We want to foster diversity, humanitarian concerns. But remember that only 15% of the US population is not native born, and a large significant percentage of that is already naturalized citizens. What does this all mean in terms of the numbers? In terms of the numbers, when we look at it, there is actually a very limited number of available visas every year that are given. There's a cap. It's not unlimited. So when we're talking about family-sponsored visas, that includes immediate relatives. There is no cap on that. However, there is a cap if you're not an immediate relative. So brothers, sisters, aunts, uncles, all of those individuals are subject to different caps. And that number fluctuates from 260,000 to 480,000 a year. When we talk about that 17% of employment based, that's 140,000 a year. Refugees and asylees, That number is set by statute every year, every fiscal year, and it has been for the last few years 125,000. And then diversity visas, that's 55,000. So when we're talking about the 0.1% chance, that's why that number is so low, because you can have millions of people applying for refugee, asylee, diversity visas, but there is a cap on the number of individuals who can obtain that. So I wanted to kind of give you all a little bit of context. There's a personal story. In the late 80s, early 90s, my family came to the United States, and we all naturalized, I believe, in the late 80s. In the 1990s, after my immediate family naturalized, my mother successfully petitioned for her parents to come to the United States, but also for her two married brothers who had their own families to come to the United States. So they are not immediate relatives, right? Immediate relatives includes only your spouse, children, and I guess parents as well. So, but she was able to if I remember correctly, she was able to within about 5 years, I know for sure less than 10 years, petition successfully for both of her adult married brothers to come to the United States. I haven't gotten kind of into the weeds with how visas are doled out, but essentially, if you are outside of the United States and you want to come, you need the family member within the United States has to petition USCIS so that you can come. That petition right now can take many, many years to file. I have personally seen cases where that petition has been sitting for 6 years, 7 years, 8 years. It is only after that petition has been approved that you can then seek a visa from the Department of State. In recent years, I've seen USCIS update their website to say that they will only prioritize adjudication of applications when an immigrant visa is available or will soon be available, which is to say that USCIS will say, hey, we understand that you want to petition for a non-immediate relative family member to come to the United States, but there is no visa available. So we're not going to adjudicate this. We are going to put it in the back of the line, and we are going to adjudicate others where there may be visas available. Now, that means your application or your visa application for your family member abroad can literally sit right now for decades. And I say decades because if we are looking at the visa bulletin, so the State Department publishes monthly a bulletin that lists priority dates. So this is the priority date for F4s, brothers and sisters of adult US citizens. If it is a family-sponsored visa, F4, we look at the bottom left. The priority date is the cutoff date by which you had to have an approved application. So we're looking at right now, if your priority, if you're an F4 category, brother or sister of a US citizen like my uncles, you must have filed your application before September 8th, 2008, or 17 years prior. And unless you filed your application 17 years prior, there's no visa available for you. And that's literally in order for you to move forward and seek a visa interview at the consulate. And that number is even more dire if you're from India, because you're looking at a December 1st, 2006 date. If you're from Mexico, you're looking at an April 30th, 2001 date. And that's, again, a reminder that is to move forward to get a visa, to even get an interview at a consulate abroad. So, I think it's hard for folks to understand when asked, why don't you just come here legally? It's really, really difficult to come here legally. I know my mother did it for both of my uncles by herself. We did not have the help of a lawyer. She spent a lot of time going to the INS building in downtown Los Angeles and did all of the paperwork by herself, and was able to successfully petition for them to come to the US within five or so years. That's simply not possible today. This is a very superficial and high level look at legal immigration, but it's really intended to kind of help folks understand why it is so difficult. And a lot of that is because of, a lot of that is ARERA. ARERA really changed the immigration landscape. The focus was on deterrence. And as each administration has come in, kind of that deterrence aspect has been increasingly emphasized without any kind of significant focus or reformation in terms of kind of increasing or encouraging legal immigration. All right. There's one question: how does the percentage of increased legal residents here in the US since the Biden administration compare to the previous administration percentage? So I don't know the percentages off the top of my head. I will be honest, most of the numbers on immigrant population take a while to generate or a while to calculate. So I would say if we're looking at the current numbers, we'd be getting numbers for maybe 2023. So anything now would be largely hearsay. I can say from what initial reports seem to indicate is that there are less individuals seeking border entry right now for, I think, obvious reasons. And that legal immigration has been stalled in part because of, immigration policies that have slowed it down. There's a lot of background stuff that goes into immigration, but, for instance, as kind of the federal workforce has shifted its personnel, there's been less individuals, anecdotally, I would guess, there are less individuals kind of working to adjudicate, say, naturalization applications and LPR applications because they're working on other things. There is also a likelihood that visa applications have been stalled because there was kind of a lull in processing of visa applications while the State Department undertook a review of what they were going to do in terms of like reshifting priorities or new focuses. I would imagine that the number of individuals obtaining naturalization is going to slow down significantly because the government recently put out new guidelines for determining good moral character. So that's going to require kind of new training and involvement. So I can't really speak to specific percentages, but I think it's pretty safe to say that everything's kind of at a lull. It's definitely at a standstill. I know that the refugee admission program has been pretty much suspended since January. So with the exception of the South Africans, the Afrikaners who've been admitted, I don't believe that the USRIP program is kind of working right now, including for individuals who have been granted that status and are waiting abroad to enter. Right. So now that we've kind of talked about, the legal immigration side, I want to speak to the key challenges for undocumented individuals who are here in the United States. One of the questions, of course, is why didn't you come here legally? But then the flip side is once you're here, if you are here in the United States unlawfully, what can you do? And unfortunately, there's a significant number of legal hurdles. There are limited pathways to US citizenship. And certainly today, there's a very high risk of being placed in proceedings. Individuals can file for asylum, but they can be summarily removed depending on how they're apprehended and kind of what's happening in the city, wherever that you are. In the meantime, whatever status you are, there is very limited access to public benefits or even work authorization. And then in addition to the legal hurdles, there's also a significant number of procedural hurdles. It is complicated and a very lengthy immigration process to apply for status or to seek asylum. Once you are put in proceedings, you have you have a right to counsel, but that's counsel at your own expense. The government doesn't have to provide you with counsel. So it's expensive, it's difficult. A lot of times individuals who are seeking asylum need information from the country that they were persecuted in. So that's obviously another hurdle. And then you have the situation where individuals who may have been present in the United States temporarily under one status may find suddenly that their status is terminated. And that's just a policy shift by administration. Kind of talking big picture about asylum applications and delays. Asylum is something that is it's near and dear to my heart. it's near and dear to my heart. This is a large focus of my practice at the Department of Justice during the last few years. But, there is a backlog I mentioned earlier of more than 3 million pending asylum applications in the United States. You have 1.4 of those that are pending with USCIS as affirmative asylum applications. These are applications that have been filed when individuals come to the United States, and they're filed immediately with USCIS. And that individual has not been put into removal proceedings yet. I've seen delays anywhere from 3 years to over 8 years in processing these applications. Then you have defensive asylum applications, which is asylum applications that are filed in removal proceedings after you've been placed in a removal proceeding before an immigration judge. And there are over 1.5 of those pending in immigration court. So we're talking about 3 million asylum applications. And then over here, I have a blurb under the, give you kind of an understanding of the removal process. There are over 3.7 million open removal cases as of January 31st, 2025 of this year. So more than half of the individuals in removal proceedings, or slightly less than half of the individuals in removal proceedings are seeking defensive asylum. And then you have individuals in proceedings seeking all kinds of other types of relief. Of course, the big issue with asylum is delays. There are varying delays depending on jurisdiction and immigration court. You're going to have some jurisdictions, some asylum processing offices where you have just a significant population and the delay is going to be significantly larger than at other asylum offices. I think one of the things that is often lost is that in addition to kind of the processing delay based on just the volume of applications, is that removal proceedings can take a really long time. One court has reported an average of 2,119 days until an individual's removal proceedings can be adjudicated. And then you have kind of overarching with asylum policy changes is by administration, how an individual seeks or applies for asylum becomes different, right? There was, the Remain in Mexico program. There was a CBP1 program. This is all suspended now. So individuals are getting conflicting information as to how they can actually seek an asylum in the United States. So that's all just kind of increased the difficulty of seeking asylum, not to mention the difficulty in actually obtaining a decision on an asylum application. For individuals who are out of status, and that refers to anybody who's here kind of without status, without a lawful visa, without permanent residency basis, individuals who are here unlawfully are subject to removal proceedings if they're apprehended by DHS. So there's a estimated undocumented immigrant population of 11.7 million as of July 2023. So that goes back to just the numbers are so hard to estimate that like they're always at least a year behind in terms of actually giving us an estimate. And there's a rough estimate of, say, right now, 2 million individuals in immigration court proceedings. So for folks who are immersed in immigration and the removal world, there's something we call regular removal proceedings, which are under 8 USC 1229A. That is, an individual is put into removal proceedings. They appear before an immigration judge. They have the right to appeal to the Board of Immigration Appeals, and then they have a right to go to the Court of Appeals. This process can take very many years. I had cases at the Department of Justice that were filed in the Court of Appeals maybe 4 or 5 years ago that continued to sit in the Court of Appeals. And then you have, kind of the 4 or 5, maybe 6 or 7 years, depending on the complexity of the case and which immigration court the individual came from, where they've been pending for even many more years. So you can easily have an individual who's been in the regular removal proceeding for over a decade. But then there's expedited removal, which is, the process that was created in ARERA in 1996. That is where an immigration officer can essentially, without presenting the individual before an immigration judge, summarily order the individual removed. And we'll talk more about expedited removal, but it is a summary removal process It has historically been used to quickly remove certain non-citizens without a hearing before an immigration judge. Individuals still have the right to seek asylum. So there is an initial screening process. And if they show either a credible fear or reasonable fear, they are then put into regular removal proceedings. The catch is though, right? There's an emphasis on summary or expedited, which means it's very quick. So if an asylum officer at the border says you have not shown a credible fear, the review of that negative determination is very limited. Individuals may only bring a lawsuit challenging, generally speaking, an expedited removal order if they are already a lawful permanent resident, or if they've someone who've been granted refugee or asylum status, or who is wrongfully subjected to expedited removal. And, I think the difficulty there is, what does wrongfully subjected to expedited removal mean? Changes in administration policy and interpretation can really influence that. And that's a lot of what we're seeing at the border right now. The use of expedited removal historically has ebbed and flowed a lot. So looking at this chart, I started at DOJ, and it's not marked, but I started the Department of Justice in 2010. And it was a good, I think, 4 or 5 years before I even encountered a case that involved an expedited removal order. It was just not something that we saw very much of. It didn't happen very often. And when it did, there was limited review in the courts. So we didn't see a lot of it. I will say that one of the silver linings over the last few years has been that courts have been increasingly exercising jurisdiction over these types of cases, both in the district courts and the appellate courts. But one of the issues that we are seeing in expedited removal is that because it is so summary and it is so quick and there is generally not review available, it becomes very difficult for individuals to challenge when they are subject to expedited removal and then subsequently removed. One of the things that we're seeing in the context of expedited removal now is that it should really only apply to individuals who are present in the US for less than 2 years. But it's hard to prove that you've been present in the United States for more than 2 years, right? Like, I certainly don't carry around paperwork showing that I've been in the United States for more than 2 years. So, ICE is putting the burden on individuals to prove that. Traditionally, or the traditional advice I think most people give their clients is that you don't have to answer, or, there's a privilege against self-incrimination advice. Don't say anything. You don't need to say anything. You don't need to answer these questions. But if ICE is going to put the burden on an individual to show that they have been present in the United States for more than 2 years, then suddenly, folks do have to answer. One of the pieces of advice I've seen floating around is suggesting to individuals who are here, who are undocumented, to carry evidence that they have been in the United States for more than 2 years. That includes, rent agreements, letters from friends, family, their employer, their pastor, any number of things. As you can, probably guess, the proof is kind of subject to the reviewer of the proof, the ICE officer, the DHS officer who's looking at that. So it has become a very, I think, increasingly difficult area for folks who are practicing in the immigration space, because changes in administration policy so heavily influence what is happening in this particular aspect of removal. So a very quick and kind of comprehensive or a big picture overview of the removal system and what happens to individuals is that undocumented individuals can be detained or apprehended by DHS. And the top one takes you through the regular removal proceedings. You can go to removal proceedings for an immigration judge. And again, one court said it could take over 2,000 days to get a decision. You can go to the Board of Appeals and appeal that decision. It could take a couple of years. And then you have the right to appeal to you can go to the Board of Immigration Appeals to appeal that decision. And then after that, where it can take a couple of years at the BIA, you can go to the Court of Appeals, and that can also take a couple of years. The regular removal proceeding process is slow. It is expensive. It's very difficult for individuals, but at least there is kind of a mapped out process, and it does take a long time, during which time individuals are typically not, historically not going to be removed. Then you have, to illustrate just how the summary removal or expedited removal process works, is DHS removal proceedings. That's kind of a big kind of umbrella term that, the government uses for expedited removal, all different kinds of expedited removal. There is very limited review for the Circuit Court of Appeals. There is no like 3 years or 4 years where you sit before an immigration judge, and then multiple years where you sit before a Board of Immigration Appeals, and then even more years where you sit in the Circuit Court of Appeals. One thing that we've seen in the Court of Appeals as well is that certainly in the last two Democratic administrations, the Second Circuit and the Ninth Circuit kind of developed their own processes for putting cases kind of in an abeyance, or mooting out cases, or putting them in kind of a judicial administrative closure posture. Basically, the court was saying, look, you're not really going to remove these individuals, so let's just close this case. So the case is closed. It's administratively closed in the Court of Appeals. The individuals have, the government, at the time agreed that they were not going to pursue removal of those individuals. This administration is aggressively reopening all of those cases that were previously administratively closed. So all of those individuals who have cases pending in the Court of Appeals that were judicial admin closed are now being re-pursued for removal. We talked a lot about the immigration courts and the Circuit Court of Appeals. There is if you're a lawyer, which I know we all are, the U.S. district courts have a significant role in immigration policy as well. I would say that, historically, the role of the district courts was, certainly from my perspective at the Department of Justice, was administrative APA challenges, Administrative Procedure Act challenges. We saw a lot of challenges to agency decisions, rules and policies, how those were promulgated, whether or not they complied with APA rulemaking requirements, constitutional challenges, class actions. We have significant number, or the government handles a significant number of class actions against unaccompanied minors, certain groups of visa applicants, certain groups of refugees, all that. That is kind of, traditional big government type source of immigration litigation. In the last 4 or 5 years, mandamus cases, bottom left cases, have also become an increasingly big component of the government's immigration litigation. Mandamus actions deal with all of those delays in adjudication. So when you have individuals who've been sitting on who have had asylum applications that have been sitting for 3 years or 5 years or 7 years, they might sue and say, hey, the government needs to make a decision on my application. So that number has spiked. Traditionally, I can't remember off the top of my head, but it was something like, before COVID and the big delays that came with asylum and visa adjudications, there would be maybe like 1,000 mandamus cases a year across the country. In 2022, I believe it was over 10,000. So that was a significant source of increased district court litigation in the immigration context. And what we are seeing today is an increasing number of habeas challenges, and that is for all of the individuals who are detained. And it is literally, you're not lawfully detaining me. I need to not be detained or not be removed or not be moved to this other space. And the federal district courts are the quickest way to get review of those decisions. And I think that, as we progress through this administration, that the availability of equal access to justice fees and Section 1983 and FTCA claims will become a source of litigation. Not necessarily, some of it will come to whether or not, undocumented individuals are eligible for this, but, the government is detaining a lot of people, including lawful permanent residents, including U.S. citizens. And so that will certainly give rise to 1983 and FTCA claims, and kind of determining kind of what the damages are in that context. So going back to the big issues in immigration law that we talked about earlier, I hope this, goal today was really to To give you an understanding of the shift in immigration policy in terms of this administration, what I have seen is that the focus has been on, yes, everyone says the focus has been an increased focus on enforcement, but enforcement isn't kind of specific enough. The focus is really on expulsion, not deterrence. You know, during the first administration, the first Trump administration, there's a lot of talk on like the border wall and the travel ban, but now it feels like an expulsion, right? There is kind of the immigration raids that are happening. There is talk every once in a while you get talks of denaturalization, and that is really kind of a moving people from the United States out, aggressively deporting them, not even to necessarily their home country of origin, but to, you know, a third country that will take these individuals. That effort is really also going to impact how the government deals with kind of the existing asylum backlog and the existing visa backlog, but also is going to have an impact, I think, on business immigration enforcement. One of the things that I've started to see is aggressive moves towards subpoenas and records, both in the healthcare context, but also I think businesses are going to start getting subpoenas from ICE and warrants, asking them to basically allow either blanket searches of their premises or to produce documents to look for undocumented individuals. And then finally, we have policy changes. The policy changes are kind of captures, I guess, the movement towards enforcement and expulsion. But also, you know, we are looking very quickly to a new fiscal year where the USRAP ceiling is going to be set. So that number was historically 125,000. I have no idea what the number is going to be this year. It could be zero. And I know the government has argued in the past that that number could be zero. It could be 50,000. It is just a significant decrease in the number that it used to be. And then, you know, there is also the talk of focus on civil denaturalization, review of visas, not only for new visas, but for individuals who are present in the United States who are currently present in the United States on visas, and whether or not to review those visas. So that kind of all falls within policy changes. And again, with limited resources, I mean, with the government's resources, kind of just the people it has, all of this focus takes away from the benefits side, right? From the adjudication of the benefits, from the lawful I-130s and I-485s, and, you know, kind of even working through the asylum backlog. I think this is just the same ARERA slide that I had at the beginning of the presentation. It's a reminder that ARERA was enacted in 1996, and it has been a very, very long time since Congress has done anything. The most recent Court of Appeals argument I had in the Second Circuit involved the panel being very, very upset with me for the government's position in that case. And I said, my light went on. But I said, you know, my answer to the panel was basically, that's the law. That's the law that Congress set, and I can't change that. I think immigration lawyers, I think, are all frustrated, both whether they're on the government side or the private side right now, because immigration policy has not been updated to reflect existing realities and concerns, but also it has been shaped so much by changes in policy and court decisions that aren't necessarily cohesive. You have courts in the Second Circuit and the Third Circuit and the Ninth Circuit. They're all kind of saying different things. You get circuit splits. Eventually you get up to the Supreme Court, but that's on one issue. There are so many issues in immigration law, and where an individual is and where the issue pops up, the outcome will differ significantly based on what jurisdiction you're in. So I think this is kind of when I was thinking about the focuses that ARERA had, the impact of ARERA on kind of the left-hand side, the enforcement focus, due process, family separation, the punitive environment, legislative influence, and then kind of where ARERA has led us to today. So you'll have, you know, ARERA established a foundation for prioritizing border security and interior enforcement. So you have interior enforcement, expulsion, you have the border wall, You have visa bans. When we're looking at due process, ARERA really set up that limited judicial review and relief. And so now you have kind of an increasingly, I think, difficult situation where the government's aggressive use of expedited removal process is raising serious concerns about what due process rights individuals have. There is family separation that, ARERA definitely increased deportation that contributed to it and the social disruption. So now you have situations where the government is actively encouraging individuals to self-deport. So you'll have family members who are, parents, grandparents who will self-deport, but then what happens to their US citizen children? And then there's the punitive environment, right? The ARERA set up those kind of increasingly mandatory detention policies and penalties and reentry bars. And I can't think of anything, that more encapsulates a punitive environment than alligator Alcatraz or the government sending folks to third countries that they don't even have any connection or relation to. And then there's legislative influence. ARERA really paved the way for subsequent laws like Homeland Security and 9/11, but we really have very little congressional action. We have had times where Congress has said they will kind of talk or, try to work on a bipartisan bill, but those have not been successful. We unfortunately have a situation where it feels like one side of Congress has completely abdicated to executive power. And that executive power goes to everything from the president claiming that 212F gives the president power to, not only prohibit the entry, but also the expulsion of individuals, to kind of looking at bigger issues such as what is the president's Article 2 powers? What can the president do under Article 2? And it does feel like that congressional silence does feel like in many ways an acceptance or a concession of what Congress should be doing to the president. And we see it not only in terms of immigration enforcement, but also in terms of funding. The government is capable of using funding to really get individuals, businesses, corporations, and schools. We see that with the universities. Government funding is such a big deal that they can use funding as a tool to influence or advance their immigration goals and policies. So I think that one of the biggest issues with immigration right now is nobody really knows what's going on with immigration. It certainly seems to change on a daily basis. I have very many good friends who are still in the Department of Justice, and have very many good friends who have left the Department of Justice and are working on the private immigration side. One of the biggest issues, I think, is a sense of how to keep up with the news. I'm always happy to talk about immigration. That's one of my favorite topics. And I think that there are a lot of really good folks paying attention, keeping track of policies, and preparing to address the challenges as we face them. I think businesses have been largely kind of protected from some of the more unpleasant aspects of immigration enforcement right now. One thing that we are seeing is, obviously the raids on the communities and the detention of individuals. That is the start. I do think that with the new budget or bill that was passed in July, the increased funding that ICE is going to get for enforcement is going to be spent on kind of more large scale immigration enforcement. So to the extent we see, kind of hospitals being subpoenaed for medical records, we're going to start seeing businesses and businesses, churches, other organizations being subpoenaed. I am done with my slides. So I am now going to look at the Q&A section and see kind of what questions there are. I'll start from that. Can you discuss how much of a financial incentive it is for private corporations to have more people detained or for longer periods of times? Is transfers and is this a significant concern, motivation, and agenda? I'm looking at this question about financial incentives to have people detained. I think I think your question maybe goes to the private contractors at the who are operating many of the detention centers. There is certainly that concern. There are private groups, contracting groups who are operating the detention centers, and also suggestions as to private groups, private corporations that run like small airline fleets, I guess, who are contracting with ICE to run their deportation flights. I think that there are certainly companies that are taking advantage of the opportunities that they have. I do not think that I think it depends, right? Is this a significant concern or motivation for the agenda for lack of due process? I think for some people that could be it. It's great, they're making money, but I don't honestly think that that is the government's goal. I don't think that the government is planning to, or like the main actors in the government space who are putting into place these policies. I don't think that's what they're after. I just can't see how this is financially motivated, kind of the level of hate and animosity that we're seeing. The up question that I keep looking at is, I see this as a negation of due process at the federal level. Am I missing something? I agree. It has been very difficult for anybody who has been in the immigration space for any amount of time. You know, it's hard for many of my friends who are private citizens who are seeing this happen, or have family members or friends who are being subjected to these administration policies, because it does feel like they're taking away due process. One of the biggest concerns that I have, or we all have, is that it feels like the federal district courts are fighting the good fight, but they're not, at least on the big cases that have gone to the Supreme Court, they're not getting kind of the final decision that they need in order to really change immigration policy. Because, you know, the Supreme Court seems to kind of agree with this notion of unlimited executive power. Seeing, can advocates who are warning immigrants about ICE's presence have any fear of being arrested for shielding immigrants? I think that there is a concern that ICE, that I've certainly seen, I've seen some news reports indicating that the government is taking a very aggressive approach in terms of any kind of hostility or obstruction of justice accusations against individuals who are shielding or protecting undocumented folks who are being, you know, arrested by ICE. So it is a very big concern. Does a respondent in a removal action have a right to discovery? Yes. So typically there is discovery in district court. It depends on where you are in the immigration space. But, you know, in federal court, there's always a right to discovery. In the immigration court process, I think you do have a right to what the government produces to show that you are removable. But I think that the key issue in the immigration court space is that if you are here undocumented, it is your burden to show that you have a right to relief, right? So you have, the individual who is in proceedings has the burden to show either they're entitled to asylum, they're entitled to CAT, et cetera, and they are not entitled to government resource. They're not entitled to appointed counsel, so they have a right to counsel, but the government doesn't have to give them counsel. So it becomes a very difficult issue in terms of kind of how you're going to get all your documents. And that's one of those kind of procedural hurdles to removal. It feels like undocumented individuals have no due process rights today, rounded up without any cause, beaten while apprehended, incarcerated. What potential legal claims can be filed against the government to address these abuses? Well, I think that, those go to kind of cruel and unusual punishment. I know that the government has at times in the past taken the position that individuals who are here undocumented have no due process rights. I don't think that's correct. They have some due process rights. They might have, slightly less due process rights than a U.S. citizen. But to the extent that the government is violating those due process rights, I think individuals, certainly LPRs or U.S. citizens who are detained and treated poorly are going to have FTCA claims and 1983 actions. I think that the private bar needs to start there to pursue those cases and then try to expand the detention of, trying to expand 1983 and FTCA claims from the lawful permanent residents to undocumented individuals. I think. I'm seeing some questions about companies and green card holders. That's a tough one. I mean, the green card space is very difficult right now because, I do think that the government is, I do know that there was, kind of a comprehensive overview and review of the visa application process. A lot of it is, I think, just sit tight and wait and see what happens. It is changing, I think, every day. It certainly feels like it is. One thing that I would say unfortunately, if I'm being completely transparent, one thing I'd say is that companies, especially large companies and companies that, are likely to be in the news, need to be concerned about being in a position where the government might want to retaliate against you. So you're going to have to be concerned about, say, taking a position on immigration or speaking out against immigration, because that could subject those companies that rely on, green card holders or company-sponsored green card holders that they employ, that could result in them being subjected to enforcement operations. And that ties into the whole, are they going to be, sent a DHS subpoena, or are they going to get a warrant against them to search the premises for undocumented immigrants? It's just kind of not a great space right now. It's very tenuous, and it does change daily. So I would really, consult your immigration counsel, pay attention to the news. There's a lot of right now, hang tight and see what happens next. Latino U.S. citizens are being detained by ICE. What can they tell agents to avoid? I think they just need to say as loudly as possible that they are U.S. citizens. That is my advice. I've had very many friends ask me what to do, and I've said, just say as loudly as possible that you are a U.S. citizen, and then call your attorney. And for, very close, very good friends of mine, I have said, you are welcome to call me. Their lawyer needs to file an immediate habeas action with the TRO seeking their release because they are a U.S. citizen and ICE does not have jurisdiction. And it could be a few days. What I've told most people is that it could be a few days in which you're detained, but they don't have the basis for detaining you. The key is you're a U.S. citizen, they're violating your rights, and they need to contact their lawyer, and their lawyer needs to get to ICE as quickly as possible, and the U.S. Attorney's Office where the individual resides, here, the Central District of California, as quickly as possible to get them released. And then after that, it becomes a question of, FTCA and 1983 actions. But just kind of say as loudly as possible, but not violently, as loudly as possible that you are a U.S. citizen is kind of the best advice I can give. I think that is all the questions. I'm grateful for everyone who joined today, and I hope you all found this interesting and helpful.